Okay, Chapter 3, Video or Part 4. Pretrial proceedings. Okay, so this is what happens before trial. So in a civil case, it begins with what we call the pleadings, which we discussed before. The plaintiff files a complaint. The defendant has a certain number of days to file with the court and answer. And then we go into the discovery phase of the pretrial. Okay, so here you see those main phases of the pretrial process. The pleadings are the formal statements made by the plaintiff and the defendant in a lawsuit that states the facts, the allegations, and defenses involved in the litigation. Now, the plaintiff's complaint has to contain a statement of jurisdiction. That means, why does this court, the court that should hear the case, does this court have the power to hear such a case? Because courts are limited in their jurisdiction. They can only hear certain kinds of cases. So, for example, you can't file a divorce case in federal court. Okay? So, you have to state to the court, this court, Your Honor, has jurisdiction because of this reason. Then you have to state what we call your legal theory, or sometimes also referred to as your cause of action. What this means, the cause of action means, you have to point to some statute, constitutional provision, or case law that says that you have a right to sue based upon the facts that you're alleging in the case. The flip side of that is to understand that not every wrong creates a legal right to sue. Okay? So you may have been wronged in some way, but unless you can point to a statute, a constitutional provision, or a common law, case law reason, then you do not have a cause of action or a legal theory. So you have to tell the court what your cause of action is. So it might be contract. It might be negligence. It might be product liability. It might be civil rights. It might be multiple theories. So that's what you have to put in your complaint. And finally, your remedy. What is it you want the court to do for you? If you want damages, how much? If you want injunctive relief, what is it that you want? Okay? The lawsuit's filed with the court, and nowadays in most courts, and we'll talk about this a little bit later, everything is done electronically. Okay? So when we say file, we either mean electronically or we mean hard copy filed with the clerk's office. The clerk's office then makes a copy of the complaint, and it's usually sent to the sheriff or to the marshal in the U.S. system, in the federal system, to be served on the defendant. This is a requirement of our Constitution. It's part of due process. The defendant has a right to know that they're being sued and has a right to appear and to be heard on the lawsuit. Okay? Attached to the copy of the complaint and served on the defendant is a summons. The summons tells the defendant, you're being sued, this is what you have to do to protect your rights. You have to file an answer within so many days with the court. Okay, so this is what a complaint looks like, and this is a federal court complaint. Okay, so if the plaintiff files a lawsuit and the defendant fails to answer in a timely manner, then the plaintiff automatically wins, and we call that a default judgment. If the amount in controversy, the amount that the plaintiff is seeking, is a clear, definite amount, we call that a liquidated amount, and the judge will issue an order for that amount. So the judge will issue a judgment or an order saying the defendant owes the plaintiff $1,500. If it's an unliquidated amount, meaning that it's not clear the exact amount, it has to be proven at trial, then there'll be a special hearing where the plaintiff has to show the amount of damages, the unliquidated damages, and then the judge will set that amount. So typically, if you have a small car accident, you sue the defendant doesn't answer, you get a default judgment, but there's unliquidated damages because you have to come to court and present to the court evidence of the damages. So usually the court's going to want to see at least one, usually more, estimates from repair shops as to how much it's going to cost to repair your car, or what the value of your car was if it was totaled. Okay, so this is what the summons looks like that we talked about a minute ago. Okay, so how do you serve the defendant? There are various acceptable means of service. The one that is expected to be done in most cases is personal service, where the defendant is handed a copy of the complaint and answer. With a corporate defendant or another business entity, you serve what's called the registered agent, which is the person that the corporation has selected as their agent for service of process. And that is usually recorded in their documents with the Secretary of State's office. If a partnership is involved, you can serve any general partner, and that's personal service. In Georgia, it's also acceptable as personal service if the process server, usually the sheriff, goes out and the person who's being sued is not at home. If you leave the documents with a person who lives there and is of a suitable age, then that's considered acceptable. Okay? So, if you have a 15-year-old who would generally be considered suitable age, sheriff comes out, hands the papers to the 15-year-old, and like most 15-year-olds, puts it on top of the refrigerator and forgets about it, and the time to answer passes, guess what? You lost. You have a default. You've defaulted. Okay. So that's one method of service. There are other methods of service, such as waiving service or acknowledging service, where the defendant signs a document saying that they agree that they've been served and they get a copy of the papers. That's usually done where the defendant already has a lawyer and the lawyers have already been talking about the case. In some cases you can do service by mail, and that is becoming a more preferred option, where the plaintiff mails the lawsuit, the summons, etc. to the defendant. The defendant then files a statement saying that they've received the documents and everything is cool. If the defendant refuses to sign anything or ignores it, then the plaintiff has to serve the defendant personally. However, the defendant then becomes liable for the costs of that service. So there's an encouragement there, monetary encouragement, for defendants to simply say, okay, we got it through the mail, it's cool, we've been served, and we go forward from here. Also, in some few cases, you can have other types of substituted service. For example, you can do what's called publication, where you publish in a newspaper that you're bringing a lawsuit. It has to be the official legal organ of the county where the defendant resides. Another is a type where you tack the court papers on somebody's door. That is a common practice in eviction cases where you cannot locate the actual tenant defendant. Okay, so the answer is the defendant's response to the complaint, and the defendant has to file that. The defendant has to either specifically admit each allegation, specifically deny each allegation, or state that the defendant has no or lacks knowledge of the alleged facts sufficient to form a belief as to the truth of those facts. In other words, the defendant saying, I don't know, I'm going to try and find out. As a matter of law, that acts as a denial. Okay? All of that has to be done in good faith. Okay? That's in a notice pleading state. In a code pleading state, it's a little bit different. I'm not going to get into too much detail there, but let me just say that people who have worked in code pleading states come to notice pleading states, they make mistakes and they end up losing cases because they file answers that aren't under the law. Because the law says you can only do those three things: admit, deny, or say you're without sufficient knowledge. You cannot do anything else. Okay, so you can't say something like, I don't know, or you can't say something like, I demand specific proof of the same. Those are common under code pleading states. Okay. So the defendant, and we're going to stop there just in case I'm running out of bandwidth. We'll come back and talk about the defendant's answer in 5.